We get started. We can call the meeting to order. Pledge of Allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Okay, item 1B is approval of a flexible agenda.
I'll make a motion.
Second.
Who made the motion?
The motion.
Okay, thank you, Linda. And second. Okay. All in favor, say aye.
Aye.
Aye. Opposed? Okay, pass 6-0. Okay. Before we open public comment,
Mr. Burns, we need to remember that Carrie is online.
pardon? Oh, I'm sorry, is Carrie online?
Is he
Okay.
having difficulty? I know he was having difficulty before the meeting started.
Okay, just let me know when he gets in there. Okay, before we start public comment on the agenda action item, I want to remind you, you should have the information of what it covers. Please stick to the agenda as close as possible. Please do not address anything else but that agenda item. There will be some information that will be given out, maybe give a little bit clearer, but this was drawn up for this particular reason. And if we take and get a disturbance going on, this meeting, I could call for a closed door. We could originally. Mr. Alvarado asked to be an open meeting, and I said, that's fine. So this is a meeting that's a little bit different on an agenda item, so it's not real clear. It's just where we're headed with it on this. But I won't hesitate to do that if I have to bring it so we can finish business. So, Mr. Alvarado, I'm sorry.
Because this is very unclear to the public and I've received a lot of emails, would it be at all possible to hold public comment after we have a discussion?
We cannot change the order right now. I'm not going to change the order. We need to get some clarity here first.
Well, yeah, no, we can. We approved a flexible agenda. And so it would make sense for the public so that they know what they're actually speaking to if we have discussion and then open it up for public comment. Then we can continue to discuss and then vote.
We'll make public comment on number 4. And if the board's okay with it, if there's no one opposed, I'm more than happy to open up for the discussion on the agenda item on number 4 with it.
Do you mean number 3?
Oh, I'm sorry. Is it different? Mine says 4 too.
I guess I'm confused as to what you're.
We have a second public comment.
Right. And usually that's for anything not on the agenda.
Correct. And that's the reason why I said if no one on the board is opposed to it, we can open that up and allow both to happen on number 4.
Would that be before we vote or after we vote?
That would be after we vote. Number 4 will be at the very end.
Then I guess I'm confused as to why we would open it up for discussion and then more discussion on our part.
We have to have 2 discussions, public discussions. There has to be 2. I can take
Right.
it as number 2 and move the public comment down past the agenda item. But then we have back-to-back public comment.
I think what she'd like to see is us discuss the issue, have public comment on it, and then we can vote on it. Correct?
Correct.
I understand that. Oh, between voting and,
After
Public comment.
discussion, have public comment, and then we vote.
okay, we have,
Because it is vague what we're discussing here. So I don't have a problem with it either way.
okay. Everybody good with that? No one opposed? Okay, we'll do that.
I just want to ask too, one other thing. Thank you for that. Is there a way that we can, sorry, I'm trying to see if Carrie got on. Is there a way, excuse me, is there a way we can clarify this agenda item before we even begin? Because I also have had people ask me about it and I don't want to say much because I don't really understand it myself.
I don't either.
So you didn't make this agenda item? Who made the agenda item?
For the agenda item itself was created and approved by legal counsel, am I correct?
Did you make this item?
I helped draft the language. I did not make the item.
And who did you help draft the language with?
The superintendent.
Okay, so this came from the superintendent to you, and then it was asked to have a special meeting. You called the special meeting, but it was asked by the superintendent? Is that correct? I'm just
I
trying to,
called a special meeting.
yes, but he asked, but Superintendent Alvarado helped
After
make this
seeing,
and then,
after
came to
seeing
you.
what, after seeing what was going to be on the agenda, I called for the special meeting.
correct. But you were asked to call for a special meeting.
I wasn't really asked to. I've just explained what this was
Okay,
going
that's
to
fine.
be.
That's fine. We know where it
Okay.
came from. Thank you.
All right. So in public comment, we'll move after the superintendent. Number 3 will become number 2. Number 2 will become number 3. Superintendent to act on behalf of the district for the matter related to Ricky Dean Miller versus Douglas County School District, case number 2023, CV 00162, discussion for possible action. Mr. Alvarado, do you want to, or legal counsel, either one, want to give some clarification on this? Thank you.
So it appears that there's confusion. For some reason, people think that what we're doing is trying to delegate power to the superintendent to act as legal counsel on behalf of the district. That's not what this action item is calling for. What this action item is calling for is to delegate power to the superintendent to act on behalf of the district while engaging with legal counsel to move forward in this matter. We just lost second legal counsel. There's a true conflict between the different factions on this board. So our independent counsel just felt the need to withdraw. So as counsel for the district, it's our job to represent the district as a whole and to try to determine what's in the best interest of the district. And at this point, it seems like the best interest of the district would be to delegate the authority to the superintendent to move forward with this matter with new counsel. We hired him as the superintendent, and I believe the board needs to trust him as the superintendent to move forward in this matter and act on the best in the best interest of the district. So that's what this this action item is calling for.
Is that, now, can you clarify district?
Yes, so we have in the writ matter, there's two respondents. There's the district and then there's the 4 trustees. The 4 trustees are being represented by Rob Smith, and up until recently, the district was being represented by Anthony Hall. So Anthony had to withdraw based on certain conflicts. And so I believe that Mr. Alvarado is in the process of retaining new counsel. And so for the district, not for the 4 trustees. And so he would work together with counsel for the district in this litigation, whether it's towards settlement, whether it's moving forward with litigation, whether it's representing the district at the hearing that's already scheduled, but he wouldn't be representing them as legal counsel. The new attorney would.
And I take it none of the trustees will have any knowledge of any process here.
Right, the 4 trustees will, none of the trustees at this point moving forward would be engaging with the new council. We would delegate that authority to the superintendent. The 4 trustees would not be able to engage with council, and the additional 3 trustees would not be able to engage with this council. We would leave that to Mr. Alvarado.
Okay, is that cleared up? Okay. Okay, I'm gonna,
Excuse me, I need some more information.
okay, go ahead.
So there are 2 people that have applied. Am I to understand that? We have 2 applicants to take this project on. Is that?
In terms of attorneys, we
Yes.
received 1 engagement letter from 1 attorney on Friday.
Okay. Okay, I don't know what I can and can't say because everything is I'm just so over it. I was to understand there was an attorney that, and I could be wrong here, that is working on behalf of these 3 of our trustees that has offered to do it. I think that's a conflict of interest, and I think that's wholly inappropriate.
That's not. on
Okay,
here.
well,
Months ago, the board voted, months
ago.
ago, the board voted to delegate the superintendent the authority to choose counsel for the district. So he currently has the authority to choose who represents the
Then why
district.
are we here?
Because now you will vote to either delegate authority to the superintendent to act on behalf of the district moving forward in this litigation, because at this point it has been the other 3 trustees and their independent counsel trying to work with the council that was delegated by
Understand.
Ms. Dwyer, based on conflicts with that representation, he had to withdraw.
Mm.
And so now we believe that it is cleaner and in the best interest of the district for the superintendent to engage and act on behalf of the district with district council moving forward.
Okay, I just have a hitch in my anyway. Okay, thank you very much.
Okay, let me make something clear. Confidentiality is extremely important in this case too, not just all the rest of them. Confidentiality must be kept. Okay? Well,
There's certain issues with attorney-client privilege is what I think you mean.
Yep.
The 4 of you shouldn't discuss anything that has been discussed between you and your counsel. We don't know anything that's been discussed with the 3 trustees and prior counsel, but that's one of the issues. And so while we can't discuss the particulars of any discussions that took place with either council, there have been conflicts and ethical concerns that have arisen. And so it will be cleaner, cheaper, and in the best interest of the district, as far as we see it, to have the superintendent who was hired for this purpose to act on behalf of the district in the best interest of the district to move forward and work with the new district council in this matter.
Okay. Any more on the explanation? No. You have any more questions for the explanation? You have a question? Go ahead, Doug.
Well, I'm still trying to clarify here exactly what we're talking about. Joey Gilbert Law is the district council or not? General counsel.
Yeah.
So
So Joey Gilbert Law is District General Counsel. At a certain point in this matter, it became apparent that there was maybe divergent interests. We still don't truly believe that to be, but some people believe that there are divergent interests between the district and the trustees. At that point, Joey Gilbert Law couldn't move forward representing both parties. So what happened at that point is we gave Ms. Dwyer the ability to delegate counsel for the trustees and for the district. So at that point, the superintendent was only given the ability to choose counsel for the trustees and the district. Since then, the 3 trustees and their independent counsel have been representing the district with the district council in this litigation based upon concerns or conflicts that council had to withdraw. So now we have to get new counsel. At this point, it's believed to be in the district's best interest that rather than have the 3 trustees and their independent counsel move forward with the new attorney, which will just result in the same impasse, we believe that it may be in the district's best interest to delegate the ability to the superintendent to represent the district while working with new legal counsel moving forward in this litigation.
For everybody, all of us?
No. You guys have your legal counsel, Rob Smith. The district had their legal counsel, Anthony Hall. Anthony has since withdrawn his representation. Frankie is in the middle of hiring a new attorney to represent the district. We are now having discussion and voting on whether Frankie will have the ability to engage and move forward with the new legal counsel in this matter, or if we keep it as is, which is the other 3 trustees engaging with legal counsel in this matter.
with their current legal counsel or with district legal counsel that,
Okay. We are Joey Gilbert Law is general counsel. Joey Gilbert Law is not representing the district in the writ litigation matter. Rob Smith is representing the 4 trustees, you 4 trustees in the writ litigation matter. He continues to represent you. You guys work with him. We had Anthony Hall, who represented the district. Because there's the petitioners and they sued the district and they sued the 4 trustees. So we have the district as one entity and technically the 4 trustees as one entity in this litigation.
wouldn't there be another entity, the other three trustees?
Well, up until now, they've technically been working with district council to represent the district. And so that's what this meeting is for, to determine whether or not you're going to take that power from the 3 trustees and delegate it to Frankie to move forward and work with district council in the writ litigation.
And this has all to do with record requests.
only to do with the public record requests. All of the documents which have been requested at this point have been produced. And so it's really just moving to the finish line in this matter.
Okay, I get it now. That was helpful. Thank you. I mean.
So
no,
this is
it
all
is-
because of, we've submitted all these record requests. Now we just have to prove that we've submitted all these records or something.
So at this point, I believe all of the records have been submitted, at least any records that exist. The parties have engaged in third-party discovery by a neutral discovery company. All of the documents, I believe, have been produced. Now it's just determining liability and resolving the matter. But I have very limited knowledge about the actual litigation because we haven't been in communication with counsel. We washed our hands of that as soon as there appeared to be any sort of conflict.
So if we allowed it to stay the way it is, it's a great potential, correct me if I'm wrong, it's a great potential that if we did get another representative for the district as an attorney, he could do the very same thing that the first one did. Am I correct?
It is likely that if things move forward as they are, that the same conflict will exist.
Okay. Anyone else? Anything?
What, can we have a discussion?
As long as we're clear on all the questions to legal counsel for a description of what's going on. That's what caused the confusion, but you can't put all that down on paper and still expect everybody to know what it is. I'm not an attorney,
Right.
so Doug, you good?
No, I'm thoroughly confused, but we'll keep going.
We have, so
Well, I mean, to me, this whole thing is incredible waste. That why don't they just drop the case
we agree.
and we'll move forward?
Can I say one last thing? I would like to make it clear that even though if the board votes to approve this action item, it doesn't take away the board's final approval. So anything that Mr. Alvarado and the district, if it comes to resolution, again, if they come to settlement, it would again come before the board for discussion and final approval.
Can I ask a question?
Go ahead.
So if it still has to come before the board for final approval of any settlement, then what exactly will Frankie be doing? I guess that's what I assumed you were talking about.
Well, he would be working with counsel to come to a resolution with all of the parties. And then if if they do come to a settlement resolution, then that settlement will again come before the board for the board to vote on whether or not to approve, just like the last time.
Is that settlement something that we would be asked about before? Like it's given? I'm just trying to understand.
It would be discussed and you would be able to vote on it. And if you don't approve it, then it's back to the drawing board, just like has happened multiple times.
So we'll still have legal counsel.
The district will have legal counsel.
Right.
Yes.
That's what I mean. I'm sorry.
Yes.
Yes. Clarifying there. So Frankie would just work with the new legal counsel.
Yes.
in working out a settlement, but then the final settlement would have to come before the board
In an open meeting.
in an open meeting to be approved or denied.
Yes.
Okay, there's,
I have one
Go
more,
ahead.
I'm sorry. Well, I'm not sorry, but, so we've been open. The district, the three of us, when you say the district, you're talking about the three trustees, correct? So the district has been open all along with who we would like to have as our attorney. And, why would we not skip that? Why would we not just go ahead and hire who we would like to have represent us instead of spending time and any other money looking to hire somebody else? That's my question.
The board delegated the ability to choose legal counsel to the superintendent at this point.
That was
Uh,
Jeannie Dwyer at that time?
The superintendent.
Jeannie, okay,
And so now Frankie's the superintendent
right.
and he gets to choose who he wishes to be legal counsel and who he believes would be acting in the best interest of the district. At this point, there are certain conflict and ethical concerns. And so it,
When you say conflicts and ethical concerns, are you talking about the attorney that we're interested in having represent us?
I don't feel comfortable putting any of that out there. Linda, there's certain.
Okay, but you could just made a statement, so I just needed it clarified. That's all. That's the reason I asked.
I don't know if I'm allowed to say this, but the conflict of interest is the person who's written numerous negative articles about 4 people on the board. She and her husband have
That
both
has-
sued
okay.
multiple.
Nothing.
So,
So when I hear, I have to be honest, when I hear that, and I've heard it from 3 board members say those things, I'm wondering if the tail's wagging the head of the dog, because they should not have any say in who we want as representative. Now, if they're saying those things out loud in a meeting, and then I'm sure they're saying it to our superintendent, it makes me wonder why, why we can't hire the person that we want, that we would like to work with, since we're the district. That seems just to make sense to me. And especially the other thing I'll say is this person has said she'd work with us and she'll do it pro bono. So we're so concerned about money, I would say that would be a big caveat to look at. Thank you.
nope, we're gonna. I don't want to go further into discussion unless we're going into discussion, we're not coming back to clarity of what we're doing. She's laid out the clarity of it. She's laid out her concerns. I don't know who or what or why. That's up to the superintendent, just like we did with Jeannie. We're doing the same thing here. We do have I consider a conflict of interest. Conflict of interest, and the conflict of interest is I don't know if it's down the same road, but we've had threatening letters from 2 legal counsels, and for that to represent the district, I think would be a major mistake. So that's the argument on that. So now we're going to go into an actual discussion. We've got some clarity. Now let's go into the discussion of the actual matter itself. So on the on the superintendent, trustees may take action to authorize superintendent to act on behalf of the district moving forward in the aforementioned writ of mandamus legal matter. Superintendent shall be the district's representative in this matter and may take certain actions to further the lawsuit, including but not limited to communicate with counsel, negotiate with opposing party, and make decisions regarding full and final resolution of the matter. Any discussion on that description?
President Burns, can you hear me?
Yes. Go ahead.
Oh, this is trustee Kangas.
Yes.
I apologize. I got in late. I was having trouble getting into the meeting. I've been here for probably the last 15 minutes. So I missed some of the beginning, but I had a couple of comments about this item. So the first one I'll say is that, in my opinion, we should not be having another special board meeting. And the second one I'm going to say is
Mr.
it's not,
Kangas, we're on the description now.
pardon me.
We can go on the description. We have to stick to the agenda item, please.
Okay, so in my opinion, it's not ethical for any trustee who's a defendant in the writ of mandamus to vote on this agenda item. I don't think it's appropriate to have someone other than a legal counsel or legal counsel step in at this point. And that's my opinion.
Anyone else
For discussion,
for discussion?
I got plenty to say.
Go ahead.
So here's my concern. As a board, we will be asking our only employee to represent the district in talking with legal counsel on a matter that involves a majority of our board. I don't feel like he can appease the four of you and the three of us. I feel like that we are a divided board. There is no question about that. And so I have concerns that Mr. Burns, you'll throw your weight around, that you will try to convince him to do something or say something that is not in line with the way that things are supposed to be. And I don't think it's ethical that the four of you should be able to vote on this because it will impact the writ of mandamus. And there will be ethical violations and there will be ethical complaints made. And so I am strongly against this.
Anyone else? Go ahead.
You know, it's like we've already been proven guilty here. Come on now. I've had enough of this. You know, if it is against the law that we cannot, or against NRS that we cannot vote, then okay. But if this is just your, I mean, this whole idea that everybody here has been found guilty, that has not happened yet. And it may not happen at all. I just, the picture that's being painted here is ugly and it's not serving this district well from some of the board members. Thank you.
Okay.
Dave?
Let's stick to the
Okay.
actual agenda. Thank you.
Okay.
Nice.
I think that what you said about our new superintendent is very disrespectful. We voted him in. I trust him. You should trust him too. He's a very professional and ethical person. That's one of the reasons why we hired him. And I trust that he's going to do the right thing.
I made a statement earlier. I said that this have to be confidentiality is very important. I expect no different from him. This is the district representation. We do not do that. He's going to find someone to represent the district. He will work with the district representative, legal counsel, and that's where it's going to lie. He's not going to tell me anything because that would be breaking the confidentiality. And if you don't think that's true, then you're calling him a liar.
That is not what I'm saying at all.
Okay, any more comments? Yes.
Mr. Burns, what you just said, I take offense to. It's not up to the four of you to decide your own fate, okay? By allowing Mr. Mr. Alvarado, sorry, boy, that was a slip. It was. Mr. Alvarado, I apologize. You are nothing like him. I believe it's up to the district to decide who they would like to be represented by, and not by the four trustees who are in the thick of this. You have your attorney. We want our attorney. And I don't think that that saying that, you should not have a vote in this. It's total conflict. I feel it's up to the three who make up the district on this item. And Mr. Alvarado, I'm going to be very clear that I was elected, you were not. And I know that I have a right as an elected official to have some say in this. And I believe I would like to be able to have a say in who the district gets to represent on this item. Now, after this item is over with, have at it. You choose whoever you want to represent the district. But we have worked very hard on this. And yeah, I would like to have a say in who represents me being part of the district, not the other side saying that they should get to choose or they should be able to vote on this. This is definitely a conflict of interest.
Linda?
Be able to allow that. Thank you.
We did not choose Rob Smith. We had no say in it. Jeannie made that decision. We had no say. We had no knowledge. So I don't see why you think that you should have more authority than we do when we're being persecuted for complete false nonsense. And because you can't get over that you lost.
Ooh.
Okay.
Shouldn't have done it.
Who
lost?
Stick to the agenda.
I'm not even going to go there.
If we're
But
not gonna
you
do
could have
that-
chose your own attorney. If you didn't like this attorney,
Linda?
you guys could have said you didn't want him. I'm responding to her, Dave. She
I'm
just
going to
said to
call
me,
closed door if you keep it up.
whatever.
Simple as that. Be respectful, and that means everybody.
Just be talking.
I said everybody.
Didn't say anything.
Gosh, you're just like a kid. So any more good discussion on the agenda item?
I have
No more discussion.
I-
I'm going to call for a vote.
I have a question. And we can't vote until we take public comment.
Go ahead.
Are you planning on voting?
That's none of your business.
Well, it has to be disclosed.
No, I'll disclose it when I vote. I don't have to disclose anything now. Okay, we're going to open it to public comment. Make sure you get your and cut 'em. Thank you. Okay, Leslie Hulkerson.
Leslie Hokinson for the record. In the first place, I really find it a joke, and I'm sure a lot of us do, that in the past, you've tried to take away all the superintendent's authority, and now all of a sudden that the four of you got who you wanted in, now you want to give them more authority. I'm just saying that, to me, that's so hypocritical. I can't even believe it. Another thing is, this another special meeting when we were having the regular meeting next week. I don't see the need that this needed to be done today, when in the first place, maybe even if you had it at noon, a few of the school teachers could have come for at least a half hour, and maybe some of
Excuse
the
me.
parents that work.
We need to stick to the agenda. Thank you.
Okay, the agenda is, the only one that I see making out on this is Joey Gilbert. All this is cha-ching, 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 more money in Joey Gilbert's pot. That's not an hour, a minute and a half, I don't think. Cha-ching, 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 cha-ching. That's all you care about, is putting more money into their pockets and taking money away from the students and the teachers, which is what this board is supposed to be about, but you seem to have forgotten that many, many months ago.
John Walker?
Good afternoon. My name is John Walker, and I have 2 children in the DC School District. My comments today focus on just 2 areas. First, I would hope that today someone on the board or staff would acknowledge that more than $70,000 of public money has been spent on this legal matter. And second, I believe the public deserves that a cost estimate be disclosed concerning the future expenditures for the resolution of this matter. Moreover, a full accounting of legal and staff expenditures, that's staff expenditures, should be disclosed at each forthcoming board meeting until this legal matter has been resolved. Thank you.
Adrian Sawyer?
Adrian Sawyer, for the record, parent of 3 DCSD students. This item today is very concerning. It seems like the board is using Superintendent Alvarado as a scapegoat for the failure to comply with the law. Superintendent Alvarado is the sole employee of the board and must do as they say. It seems a huge conflict of interest to put this at his feet. And there's a perceived, whether you want to or not, ability for you to influence his decision. I'm not sure he signed up to be the new face of the writ, taking the responsibility off the 4 trustees who failed to comply with the public records request. It has been proven in court that there was a pattern of forwarding board emails to personal emails or family members in order to circumvent public transparency. All the writ is seeking is to hold the trustees accountable for their actions as school board members. So my question is, who can vote on the settlement once it's done? I am concerned that the board majority is trying to circumvent their conflict of interest in the writ, allowing them to vote on a settlement. That would allow the board majority through Superintendent Alvarado to come to a settlement that holds the district financially responsible and shields the board members from their personal involvement. The writ is not about the district. It is about 4 trustees who were not transparent and the public holding them accountable.
Melinda Mattis?
Melinda Mattis, for the record. I am really, really shocked at what is going on today. I had prepared some statements, but it seems irrelevant because it would appear to me very clearly that there is an attempt here to circumvent the law and to circumvent fairness in this situation for 4 people who are apparently up against a difficult situation to make an effort, it would appear to me, to have Mr. Alvarado take over 3 other people's positions. And he would then have the power, along with you 4, to make a decision, or your attorney. And it seems like all the attorneys are over here and you're trying to take away their ability to protect themselves and to address these issues in a fair, equitable, legal, appropriate manner. It's an ugly situation, and somebody is going to have to bring this group together quickly. Thank you.
Cheryl Bloomstrom.
Good afternoon, Cheryl Blomstrom. Let's set the table, shall we? I'm revising this on the go. Your duty as elected trustees is to take the tough actions and considered decisions your office sometimes requires. I don't think it is ethical or appropriate to delegate a task like what you propose to the brand new superintendent, particularly in light of the ongoing legal actions and unresolved issues. You are wrong-footing him right off the bat, and that's entirely inappropriate. As well, the 4 board members who violated the Public Records Act and as a result are named in the lawsuit recused and should stay recused. If not, there is clearly a case for the Ethics Commission to hear about it. Given that the question of personal liability for the 4 members is also still in play and unresolved legally, this delegation of authority is premature, unwise, and unnecessary. Consider what you're doing. Take a minute, take a breath. You've got 4 of you and 3 of you, and somehow you need to have 7 of you working together. This 4-3 on the tough votes is nonsense. And it's important for our children, for our district, for our staff, and for our community that we prosper us in ways large and small, and that's on you guys. So take a minute. Don't do this to Mr. Alvarado or to us.
Thank
Thank
you.
you.
Virginia Sterrett.
Virginia Sterrett for the record. First, I want to make absolutely clear that none of the 4 trustees sitting in front of me have been found guilty of doing anything. A settlement was reached, but there was no mea culpa. There was no admission of guilt. So all those people arguing about the guilt of those 4 people are arguing completely on the wrong foot. And there has been so much dissension based on political differences. The 3 trustees against the 4 trustees, it's not anything to do with the district or the trustees or any of that. It's about political differences on both sides. And Miss Charla Hales, who came in and made it all even uglier, is a huge ethical conflict in this because she is also on the Board of Commissioners and she should be held to task. If you want to send anybody off on an ethical trail of misusing her power, it is that person who you are, some of you are arguing should be your attorney in this matter. It is entirely wrong. NRS says it's wrong. She should be held her feet to the fire. But the one person here who is new and who doesn't have any prejudice about anything here is this new superintendent. If anybody could bring a settlement together that does in fact unify the board, it would be him. And those 4 people sitting there who haven't been found guilty of anything are still representing the district. So they should get their say. Thank you.
Melinda Needing.
Melinda Knighting for the record.
I'm sorry.
That's okay. I think we need to step back and just think about this is a slippery slope we want to go down to give the powers that should be within the Board of Trustees to somebody else. In this matter, in any matter, this is what you were elected to do. All of you is to deal with these things. And I don't think it's where we want to go is to take those out of where they should be. Thanks.
Laura Cadeau.
Laura Cadeau for the record. I want to remind this board that last year at this time, Ms. or Trustee Jensen had distrust in our old law firm.
Stick to the.
I am. You need to listen to me. And we voted on an RFP. And the next month, she utilized her individual power to override that vote and decided that the Gilbert Law Firm was going to be the firm that represented you. And that is what happened. And there was no say in terms of other people coming forward. I bring this up because it was so important for you four who voted for the Gilbert Law Firm to have someone that you had trust in. So here we are with 3 trustees who are saying they want a choice in who represents them. It's not whether that person is appealing to you, it's who they want and have trust in. Precedence has been set in this matter already. And you, in order to show fairness, you need to go with what they want and not what you think is best. It is for them. Thank you.
May Hyatt?
May Hyatt. In order to distract from the truth of what is actually happening in the district, 3 self-appointed attorneys, Richard McGuffin, Charlotte Hales, and Jim Hales, along with former trustee and sore loser Rob Lehman, have ganged up against the board's majority, who have been working tirelessly to help our teachers do what is best for all students. On May 21st, David Burns wrote that in an opinion piece to the Nevada Globe. A trustee mentioned earlier that an attorney has written nasty letters and comments regarding the 4 trustees. Oh, the hypocrisy. Fellow trustees on this board are writing 2 publications bashing fellow community members, trustees, and people in this room. You have bashed me and said my name in this publication as well. The mudslinging began when members of this school board attacked people in this community, attorneys, parents, and the like. You are the ones who've created a bed of distrust, hiding behind attorney-client privilege, schedule meetings like this when DCSD staff and working parents cannot attend. Let me just say, you reap what you sow. By the way, Virginia Sterrett is one of the puppeteers Burns, Jansen, Dickerson, and Engelkirk have been emailing and corresponding with that brought you into this mess in the first place. So yeah, she's going to defend you till the very end. She's one of the people who are part of this writ of mandamus. She's one of the witnesses who needs to be called out.
Okay, thank you. Anyone else? Anyone online? Yeah, one, go ahead. All right, Courtney, we're going to unmute you. All right, go ahead.
Colin Burrows for the record. Not Courtney. Anyhow, taxpayer, am I started? I can't really tell. Hello?
We can hear you.
Regarding this item, I question the necessity of holding another special meeting for this item, especially when the regular monthly meeting's a week away. This seems to be unnecessary expenditure of taxpayer dollars. To date, on this issue alone, we spent $50,000 on Gilbert Law Firm without any tangible results. An additional $70,000 to pay the opposing law firm, which has actually demonstrated a clear understanding of open meeting law. The financial burden caused by Gilbert's law firms due to an impaired incompetence should be borne to them, not to taxpayers. Moreover, this meeting is scheduled at 1 p.m., a time when most parents, teachers, and concerned taxpayers are either at work or in school. This is just one of the many special meetings that give the impression that the new board members and Gilbert's law firm are intentionally obscuring ongoing issues from public scrutiny. The lack of transparency from the board president is troubling. It is disappointing to see that the new superintendent has scheduled this special meeting at taxpayer expense at this time. Will the superintendent address the significant financial mismanagement by Gilbert's law firm? Will there be a review of the sworn affidavit submitted by the 4 board members, followed by a comparison of the court testimony of Jansen, which directly contradicts her sworn testimony? These are crucial issues that demand accountability and transparency. Why didn't the 4 trustees just follow the law and submit the documents required by law? And we wouldn't be down $120,000. What a horrible job by these.
Thank you. do we have a name on that one? Colin Burrows, okay? Mr. Lehman, oh, you got one more online? Wait till he's done and then back to online. Go ahead.
Rob Lehman for the record. Trustee Dickerson, nobody is saying that you have been found guilty. What has happened is since the writ was filed and after the four of you submitted sworn affidavits that no records existed, over 6,000 responsive
Mr. Lehman,
documents.
Mr. Lehman, we need to stick to the
That's
agenda.
what I'm talking about.
Yeah, well, no, we're not.
No, I absolutely am. No,
No, you're not.
and
Stick
talk-
to the agenda.
this is the
This is
agenda.
not- you-
I'm
this
setting
is
up
not
my
working.
comment.
You're not going back over.
I'm setting up my comment. I'm setting up my comment. Please let me have my time again. It's absolutely true from all four. Okay. Can we start over? Okay. Are we starting my time now?
I'd be happy to do that.
Since the writ was filed, over 6,000 documents from all of you, some from all of you have been just turned over. Because that happened, we are now eligible for our attorney's fees. That's what happens. The question at hand is who will be responsible to pay those fees and any potential civil penalties. In deciding who will be financially liable, the four trustees already have an attorney who are representing you in your best interest. That attorney will argue that you have no liability and that the liability should lie somewhere else. That's what your attorney will do, and they'll represent you well. The district should also have an attorney that does the same thing. That attorney should argue that it's not the district's responsibility, that it's your responsibility, and they will make that argument. And neither of them is going to make the decision. The judge will then make the decision. Those are two opposing arguments that the judge will make the decision on. When it appears that the four respondent trustees are trying to have a say on who represents another party in the suit and therefore have a say on what that district's argument is, it would be wildly inappropriate and would be unethical for the four of you to respondents to vote on this item. You already have counsel. I would like to ask Ms. Jepson to go on the record stating whether or not it's ethical for the four respondent trustees to vote on this item. Thank you.
Okay, online.
Hi, Ross. State your name and you're free to talk. Are you there, Ross? You have the ability to talk if you unmute. We have no response.
Okay. Okay, public comment is done. We will now take vote.
I have a question here, clarification. So the three brought this case against the district and the four. Is that correct?
Mr. Lehman and other petitioners brought this case against the district.
So if they brought it against the district and they want to have their counsel, that's fine. Why does the district, so the district needs to have counsel on its own for this?
The district needs to have counsel that represents the district, and the trustees have counsel that represent the trustees.
So we have our lawyer and the three can have their lawyer And then there needs to be a lawyer for the district.
Mm, Sure. Yes, the three could have their own lawyer, but the district needs to have its own lawyer. And we've already delegated, the board has already delegated the power to the superintendent to choose that lawyer.
So what are we voting on?
You're voting on whether or not to delegate the authority to the superintendent to act on behalf of the district with its chosen lawyer moving forward in the litigation.
Who is the district's chosen lawyer? Who you got your?
I haven't entered in a contract yet, but I do have an engagement letter. I was waiting for today to
And
happen
so-
before I do this.
Would that person be different than the representative for the three?
Yes.
So again, what are we voting on?
Right now, the three trustees have been engaging with prior district counsel, who is Anthony Hall, and their own independent counsel. And based upon circumstances that arose, Anthony had to withdraw. And so now we need one, the superintendent will engage another attorney, but now to try and avoid the same circumstances that arose with Mr. Hall's representation, we would be delegating the authority for Frankie to act on behalf of the district rather than the three and their attorney moving forward in the litigation.
So as members of the board, we should be able to vote on our opinion on who is going to represent the district. The three have their legal counsel, so.
My understanding is that if this goes through,
Excuse me.
the three of us have no representation.
Hold on. You're not recognized.
Yes, it's my legal opinion that the entire board can vote on whether or not to delegate the authority to Frankie to move forward on behalf of the district in this litigation.
So what you just reflect on what Doug said, but we do not choose that person. We have nothing to do with.
Frankie will be choosing the council, and then if the board votes to delegate Frankie to move forward, he will be the board's or the district's representative in the litigation to engage with and work with legal counsel, the district's legal counsel moving forward in the litigation.
Against our legal counsel and the three's legal counsel?
I think there's confusion
Clearly.
on how this works. It will be against petitioners, legal counsel, sure. But while the trustees and the districts may have conflicting interests, some believe they do, some believe they don't, the district and the trustees are not opposing parties to each other.
So you'll be voting for your employee to represent the whole district against you. That just seems
Not against you.
so, well, yes, because the district and the four do not have the same objective.
They're not opposing parties in the action.
Explain.
The district and the trustees are both defendants. And they are not against each other in this
Separate
litigation.
defendants.
Correct. They are not against each other in the litigation. The petitioners sued the district and they sued the trustees. The petitioners are against the district and against the trustees. The petitioners and the district are not working together. And I think that's the confusion.
Okay.
All you're voting for today is whether or not you're going to delegate the superintendent the authority to work together with the new district legal counsel moving forward in the litigation. He gets to work with district legal counsel to determine what's in best interest of the district, separate and apart from the 4 trustees and their counsel.
That's a whole different lawyer, whole different situation. This is about the district.
Yeah, actually, the trustees have nothing involved.
I think this is a tangled mess.
At this point, no.
Well, yeah, because the 4 of you are telling the district and the 3 of us that we can't have certain person as our legal counsel. That's what you've said.
You have one. You have legal counsel.
No,
You
The
chose
board
legal
voted
counsel.
unanimously to give the superintendent the ability to choose legal counsel.
yes, but then today they have stated that he cannot choose a person because that's a conflict of interest. But they have a huge conflict of interest here.
They have not
Yes,
made that
because you
decision. It's
are
Frankie's
voting-
decision on
you
who
are
he's going to
voting-
choose as legal counsel.
Yes, but they're voting on something that could affect them.
Okay,
So
just stop.
having your employee represent you in a legal matter is unethical and wrong.
She's not going to get it. Okay,
For Kendra.
Kendra, do you want to take another question?
Kendra, I have a question for you. What I'd like to know, or maybe it's for Frankie, I'm not sure who can answer this. But so let's say we move forward. We know how this is gonna go because we always know how it's gonna go. So Frankie gets the authority to hire a counsel, right? So he hires X. So now we have X is the district's counsel, which is also saying the district's counsel is Yvonne, myself, and Carrie in this matter. No, you're shaking your head. No, I don't know why you're shaking it. Can you explain to me why you're saying no?
I don't understand why. I don't understand why you 3 are putting yourselves. I understand that you are working with counsel to move forward in the litigation, but really the district is its own entity. Yes, you will have the ability to vote on the settlement if there is a settlement at this point.
Right.
That becomes before the board. The council will be representing the district as an entity, not you 3 as trustees for the district.
So my question, okay, that clears that. So my question will be, we get X as our attorney, Frankie hires somebody. And like last time, we met with this attorney. Is that the same procedure that will happen again? Or are we going to be totally out of the whole procedure? As elected officials, we have no say in how this goes forward.
That's what the vote is going to be, that Frankie will move forward on behalf of the district in the litigation. And then if it comes to
have-
resolution, it'll come before the vote for.
So it'll come before the 3 of us for the vote, whether we accept whatever is put down, correct?
You can vote to approve or deny at that point.
That's what I'm saying. So at the end of all of this, no matter guilty, not guilty, whatever happens, when it comes forth to the
I would just,
district.
it's not a guilty or not guilty finding.
Okay, sorry, bad choice of words. But whatever happens, it's a settlement. Can I use the word settlement? Is that correct?
I don't know if petitioners at
would you
this
use?
point.
What
well,
word could I say?
Resolution?
Okay, thank you. I wasn't sure what to use. Thank you. So when it comes to a resolution, it will, at the end of all this, no matter what the resolution is, it's going to come before the 3 board members to accept or deny. Is that true? Is that a true statement?
If petitioners are willing to enter into settlement at this point, then that would come before the board. If there's no settlement and it goes and it's an order of the court,
Right.
then the
Okay.
trustees have no choice.
Right.
But none of the trustees.
Nobody
have
has a
at that
choice. I
point.
get that. I understand. Whatever the judge comes down with, becomes what it is. We don't we don't get a say in any of it. But if it does come down to a settlement and it's brought before the district, it'll come before the three of us as it did last time, and we'll say yes or no.
It'll come before the board. I believe if settlement is on the table, we are going to have to appeal to the Ethics Commission for an opinion on how any of the trustees move forward.
Okay.
And
so you're saying, but you are saying that on this item here, you don't have any reservation telling, as the council, telling them that they have a right to vote. There's no ethics violation for them to vote on this matter. Even if it comes down the road later that they are fined, it doesn't make any difference that they get to vote on this matter.
Yes, I
Okay.
do believe that. They do
Okay.
not have a pecuniary interest in whether or not to delegate the power to the superintendent to move forward in this litigation.
And if it becomes a pecuniary interest down the road, does that negate what's happened here? And does that make it unethical?
Not for the delegation to the superintendent.
Okay.
The superintendent has the power to move forward in the best interest of the district with the council chosen.
Okay. Thank you for your answer.
No other discussion? Yes, go ahead. Susan. Yeah, go ahead. Make the motion.
I'd like to make a motion to have the superintendent to act on behalf of the
Just 1
district
second.
for
Did you
matters.
want to ask Carrie if he had anything he needed to say or add because he's not here, but he's online?
And sometimes that's so forgotten.
Right, I just remembered.
Had it happen to me.
Okay. Carrie, do you have any questions?
I do not have any questions. In my opinion, this is totally inappropriate to have this meeting and this move forward at this time with this type of motion. And I think that this should be tabled, maybe brought back next week. And a rewording of the motion. Thank you.
You ready?
Yep, go ahead.
I'd like to make a motion for the superintendent to act on behalf of the district for matters related to the Ricky Dean Miller et al., Douglas County School District et al., case number 2023 CV 00162, discussion and for possible action.
Second.
I would like to amend that motion. That we add that the superintendent is not allowed to agree to any settlement, but that it is required to come back before the board.
I'll second that.
I thought that was already the case. I thought this had to come before the board.
I made that amendment just to make sure.
Okay.
Okay, we have an amendment on the floor.
I mean, it's going to come back before the board anyway. I mean, I don't.
Okay. We have an amendment on the floor. Is there any discussion on the amendment? No discussion. We'll take a vote on the amendment. All in favor to add the amendment, say aye.
Aye.
Those opposed, say aye.
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 Say nay.
Or say nay. Hold on a minute. This is about, sorry, this is just a lot. It's a lot. So we are
This is the,
amending something that's just naturally going to happen by the way the board functions. I'm a nay. Thank you.
okay. Carrie?
I'm gonna say nay.
Okay.
Are you naying the amendment or the
amendment.
agenda item?
I'm sorry, what, again, this is getting convoluted. The amendment, I feel this whole meeting's inappropriate, so I'm having a problem discerning between each motion. So I will go back on my nay and make that a yes for the amended motion.
I have,
So the amendment
I know.
passes 4-3.
okay, so Carrie, you said
Yes, Doug said yes to the amendment.
yes to the amendment.
Okay.
I said yes too, Mr. Burns.
Two. Okay,
I'm still an A.
we have,
I'm an A.
we have 4-3. The motion passes.
It's gonna happen anyway.
Now we'll go to the vote on the original motion. You have that written down? No? Annie, do you have that written down? Could you?
She just read it off the agenda.
I would like to make a motion that the superintendent act on behalf for matters related to Ricky B. Miller et al. Versus Douglas County School District et al. Case number 2023 CV 00162.
Okay. All in favor of the motion, say aye. Aye.
Aye.
Opposed?
Nay.
Nay.
Okay, motion passes 4-3.
As amended.
Okay,
So that motion passes with the amendment.
yes, the amendment is on the motion.
Just making sure that's on record.
Okay, final public comment. Okay, Leslie Hokinson.
Leslie Hokinson, for the record, all I got to say again is I think this was totally inappropriate to have another board meeting like this called special so that the parents and teachers and students, believe it or not, some of the students even come to these, could not come because they're in school. Totally inappropriate, and all it is cha-ching, 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 cha-ching for Joey Gilbert. Cha-ching, 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 cha-ching. Thank you.
Melinda Mattis.
Linda Matus for the record. I think that what just occurred is yet going to be another lawsuit. And I think that this was a predetermined situation that took the right of legal counsel away from 3 human beings. It was a game. And it's going to be another lawsuit. When are you going to talk about the kids? When are you going to address the needs of this district? How long? This is 2 years. How long are we going to play these games and cost this school district and the taxpayers of this county? Why? For a political game? Is this really what you want to do? I am sickened by what just happened. It was clear that this was predetermined, and you just took the rights of 3 people and many, many civilians out here because you're working in collusion. And the lawsuit will be coming. I am certain of it. And here we are. Kids? What kids? Who cares about the kids?
Adrian Sawyer.
Adrian Sawyer for the record, parent of 3 DCSD students. I would like to address public comment. I am 100% in support of the First Amendment. While I found the public comment at the last meeting vile and in poor taste, he had the right to express his opinion. Where I find issue is that the school board meeting is not the place for his crude comments. The school board has nothing to do with deciding who the next president is. Second, the commenter was allowed to continue because he was expressing his First Amendment right to criticize public figures. I would like to remind the board that you are all publicly elected officials and therefore open to be criticized in the same manner. The board has set a precedence that day by disregarding the disclaimer and allowing individual public figures to be called out by name. If this board does not allow community members to express their opinions about individual board members, they will be violating open meeting law. As public figures, your actions as board members are open to public scrutiny. You signed up for this.
Rob Lehman?
Rob Lehman, parent of two, given a little bit of time between the last time I was up here, Ms. Dickerson, I was able to check. And after you did a sworn testimony of having no records, over 100 were produced from your devices. Items that you said didn't exist. Mrs. Jansen, same thing, over 100. It's true, it's facts. Sorry about that. That's just true, and then it's facts. Here's what I want to question. In the May meeting, there was a discussion about whether they could ethically vote. You said nobody should vote, that you should take it to the Ethics Commission in the Attorney General's office. They still voted, but after that item, Mr. Burns made a motion that we take it to the Ethics Commission to find out. That passed. That was board action in May. You said it would take 45 days to figure that out. I'm asking what has happened since then. I assume you followed the board action and you took it to the Ethics Commission as was passed by the board. Where does it stand now?
No one online? Okay. Anyone else? Go ahead. Virginia?
Virginia Starrett again. I'm happy the board moved forward somewhat today in settling this lawsuit. And I know that because of political reasons, that there's a huge fight going on over school board seats and things. And a lot of the argument ends up being aimed at Joey Gilbert and his fees. But I find it peculiar that it's always laid at the feet of the 4 board members who actually have been found guilty of doing nothing yet. And it isn't laid at the feet of the people who brought the lawsuit. The people who brought the lawsuit had no real reason to bring that lawsuit. I am the one sole witness they're depending on to prove their lawsuit in a funny way. And I can tell them now, because I can, that no testimony I give will actually back up anything that they have claimed in the lawsuit. And I'm in the legal field. I came out of the legal field and my husband is an attorney. And I can assure you that I have nothing to add that is going to build the case that they originally made for that lawsuit. When the settlement was offered, and there could have been a much less cost all the way around to this lawsuit, the 3 board members sitting here complaining about the money decided to squash that settlement and make it not happen. So if any blame is laid for these costs about this lawsuit, it should go to the 3 trustees who didn't accept the settlement on.
Thank you.
Thank you.
No.
Cheryl Blomstrom, you're here today because 4 of you, plus some other folks that are in the audience, decided to violate the law. You decided to skip open meeting training. You decided that your opinions mattered more than the other 3 trustees. And when that didn't work out so well, and you were sued for an open meeting law violation, you didn't produce any records. I guess you were told you didn't need to. When you produced records, you produced incorrect and insufficient records, incomplete. And you signed an affidavit that said you were giving everything up. You didn't. And so the basis of what's going on now is because you chose to violate the law. You chose it. Don't shake your head at me. You chose it yourself. Well, or you did it in ignorance. Those are your choices. But the point is, you started it. And the people that are bringing the writ at this point are doing it because you didn't fulfill your duty. You have a legal obligation to fulfill your duty. You chose not to, or whatever. And now they had to sue you to get records in order to perfect the open meeting law mistake, well, violation, huge violation. So the only recourse people have is to bring a lawsuit.
Thank you.
Allison Gray. First, I wanted to thank two of the trustees, Engelkirk and Wagstaff, for both enabling public comment at an appropriate time in the meeting. That was very helpful, and it brings more trust from the public when people have an opportunity to speak like that. And I don't want to sound like a broken record, but I'm really concerned about the behavior going on in these meetings. We've got one member who says somebody is a sore loser, another one who says someone is acting like a child, another one who says she's not going to get it. We have people who speak here who call members losers. We have people who use the expression slut whore to describe people. This is unacceptable, and the president needs to control these meetings. I hope the president is listening, so he's busy looking at his papers, so probably he is not. But I'm asking you to run the meeting appropriately and fairly, please. And that is, yeah, it would kill him to actually look at me because that would be polite, but I can't do anything about that. So anyway, I'm just asking, please be fair and please stop having a double standard for the people you like versus the ones that you don't. Thank you.
Anyone else?
May Hyatt. I'm a parent of 2 kids in the Douglas County School District. I'm an advocate for transparency. It's pretty upsetting today. I had to take off work to come here because being an active parent is important to me. I wrote to the superintendent expressing my disappointment regarding the appointment of this meeting. When I pulled up, I saw that that wonderful gentleman is here. He shouldn't be here. This meeting shouldn't have happened right now. He should be at Carson Valley Middle School protecting my kids. That's where he should be. That's what he should be paid for, not here. And that's what's really disappointing for me. My kids' safety, the children's safety is compromised when you hold special meetings like this, at times like this. How much money are you wasting by holding special meetings time and time again? You should have had this during an agenda item at a regular board meeting. Instead, President Burns is scheduling these meetings at inconvenient times for the community. I wonder why. Because you don't want pushback? You don't want people like me to talk and express our discontent? Again, you reap what you sow. You don't want to listen to me? You don't want to look at me? You want to put those earplugs back in? You want to walk away before the meeting's adjourned? Thank you.
Anyone else?
Don't forget
Well-
online.
We have an online. Good. Okay. Meeting adjourned.